Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello, and thank you for joining us today. My name is Gina Bertolini, and I'm a partner in the Healthcare and FDA practice group of K&L Gates, and I'm joined today by my colleague, Rebecca Schaefer.
Thanks, Gina. Yep, I'm Rebecca Schaefer, also a partner in the Healthcare and FDA practice here at K&L Gates. Glad to join you today.
During this podcast, Rebecca and I will be talking about the regulatory and the contractual considerations with data transactions. So we've always known within the healthcare industry that healthcare-related data has incredible value to patients and to healthcare providers and researchers and entities developing devices, drugs, and information technology. In the last 10 to 12 years, driven in large part by government mandates such as the EHR incentive program, the use of electronic health records and computerized order entry, lab information systems, and other forms of health information technology that use and capture health information in electronic form has really become the standard among healthcare providers. And that has led to the increased ability to transfer and exchange health information, both for clinical and research purposes. But in addition to the ability to store and capture and share health information electronically, we have seen the rise of data analytics and other information technology that really allows a much deeper analysis of large volumes of data. And that has tremendous potential for healthcare, whether that be for clinical use, research, or development of products and tools that will improve our ability to prevent, treat, and cure disease. So it really should come as no surprise that we've seen this tremendous growth in the volume of health data. One estimate is that about 30% of the world's data volume is currently being generated by the healthcare industry, and that number is projected to rise to over a third by 2025, which is higher than any other industry. It's really quite staggering. And we're also seeing the types of data change as the technology changes and the analytics change. So we're seeing data that is more precise, for example, genomic data. And we're also seeing a broader spectrum of biospecimen availability. So when those raw materials are combined with powerful analytics and other technology and clinical health information, especially clinical health information that covers a broad swath of patients and demographics over a longer period of time, you can really drive discovery, diagnostics, and new therapies. So with all that value on the table, parties are looking to structure transactions to access that data. Rebecca, can you get us started just by answering the question of what is a data transaction?
Thanks, Gina. So quite simply, data transaction is an arrangement where the subject matter of the transaction involves the creation, sharing, or use of data for financial consideration, rather than the subject matter of the transaction being some other initiative and data is an adjunct or a support. It's here the central activity that the parties are undertaking together. And a few examples of data transaction models, most simply, could take the form of a licensing deal or a collaboration agreement where data are being made available and the recipient's going to use it to, drive discovery or maybe commercialization of a product. There's also co-development or joint venture models that might take a little bit more of a formal structure to maybe even create a new entity and use that as a vehicle for the collaboration and the parties' shared activity that's going to harness the power of the data that's the subject of the transaction. Another emerging model with great degree of popularity are consortium models, where a number of parties come together, whether through a formalized legal entity or on a contractual basis. And the interest in consortium models include its ability to scale aggregated data where you've got multiple contributors. And also it's a means to distribute expense across the parties where there might be, for example, really large storage and compute costs for working with data sets of the size we're contemplating. But for purposes of this podcast, we're focused on transactions involving personal data, genomic data, or data that were derived from protected health information. and really channeling the perspective of providers and other healthcare industry stakeholders that are looking to harness the power of large-scale multidisciplinary data sets of the kind you described, and applying those advanced analytics to these large-scale data sets to drive innovation and discovery and the advancement of medical therapies. It's also a new source of revenue, provided everything can be structured appropriately. So with that segue, obviously, we know you can't sell PHI without individual authorization. So, Gina, can you talk a little bit about how this can work under HIPAA?
Yes, thank you, Rebecca. Before I talk about how this works under HIPAA's privacy rule, I just want to mention an observation related to these data transactions, and in particular on the healthcare provider side, the willingness of healthcare providers to engage in these kinds of transactions and share their data. And I'll just mention that I was in-house at 2 large academic medical centers, and so frequently negotiating with vendors and other third parties related to data. And now as a partner at K&L Gates, I do that same type of work for large health systems and hospitals and academic medical centers. And I've certainly seen a significant shift in, I'd say, the last 5 to 7 years in particular, related to healthcare providers' willingness to engage in these kinds of transactions. Whereas before, 7 or more years ago, I saw a serious reticence or circumspection around the third-party use of covered entities' protected health information, and a desire to really protect that information from third-party use, even for development purposes or developing technologies, products, drugs, et cetera. And in some instances, even for research purposes. And by and large, healthcare providers, I think, resisted those kinds of disclosures. And I've seen that shift over the last 5 to 7 years, where today, for a lot of the reasons that we've talked about in this podcast, we are seeing the willingness on the provider side, in particular among covered entities who create and maintain and have access to this type of data generated from their patients, that they're much more willing to appreciate the value that sharing data in permissible ways can have in terms of the development of therapeutics or diagnostics or technologies that will benefit their patients. So we really have seen a pretty significant shift. And then that leads to your question, which is a great one, of how can the data be shared in a way that's consistent with HIPAA's privacy rule. So most people understand HIPAA at a high level, that data called protected health information, or PHI, can be used without patient authorization for certain purposes, but very limited purposes. Generally, we call that treatment, payment, and healthcare operations, or TPO for short, or as required by law. But otherwise, that data is highly protected and cannot be used or shared unless it's authorized by the patient. So you can get a patient authorization and then use it consistent with that authorization. There are a few mechanisms that HIPAA's privacy rule allows for the disclosure of either a limited data set or de-identified data. So the limited data set I'll address very quickly because I think it has limited utility for the purposes of the data transactions that we're talking about today. But where there's a use for protected health information for healthcare operations or for public health purposes or for research, a covered entity can create a limited data set from protected health information. So that would be not all data elements available in a patient's medical record, but you can take certain of those data elements that would result in a limited data set. And the privacy rule outlines those specific data elements. You've got to enter into an agreement that assures the protection of that data. So you enter into a data use agreement with the recipient of the data, and the recipient of the data must commit to certain protections and the terms of the data use agreement. Again, I think that approach has limited utility in terms of the kinds of transactions we're talking about today. The other mechanism that we see widely used for these types of data transactions is de-identification. So that's a common strategy where you can create a data set from protected health information that is compliant with HIPAA's de-identification rule and provide that information without requiring authorization and without even requiring, frankly, a data use agreement. Now, some entities do enter into a type of data use agreement if they're disclosing a de-identified data set, just to assure that the data will not be re-identified and that the data elements that are being disclosed are, in fact, de-identified consistent with the privacy rule. Although technically under the privacy rule, that agreement isn't required, but it is a good practice. There are two methods to comply with the de-identification rule. There's the expert determination method, where an expert looks at the data set that's proposed to be disclosed and determines that there's little to no likelihood that the individual subject of the data could be re-identified. We don't see that method used quite as much, or nearly as much, quite frankly, as the safe harbor method. That's the second method under HIPAA's de-identification regulation, where 18 identifiers are stripped and the resulting data set would be considered de-identified and can be disclosed by the covered entity. Most people understand, and it's just an important point to make, that when data has been de-identified consistent with HIPAA's privacy rule, it is no longer considered protected health information and so is no longer protected by HIPAA. You've just got to make sure you do it correctly, and you've got to make sure that there is nothing that would indicate that that information could be re-identified or that there's a risk that the individuals who are the subject of that data can be identified. And then the last thing I'll just say, because I think it's an important point and it has come up for me recently in advising clients, if you're a business associate and you have access to a covered entity's protected health information in relation to the work that you're doing on behalf of that covered entity, you don't have the right to create a de-identified data set and then use or disclose it or use it for your own purposes. You must contractually have that right pursuant to your agreement with the covered entity to de-identify. So that is up to the covered entity whether they'll allow that contractually. And if you have that contractual right to de-identify, then you can do so consistent with the terms of your agreement. And then, of course, consistent with the de-identification rule under HIPAA's privacy rule. Rebecca, in addition to the privacy considerations that I've just mentioned, what other regulatory considerations come into play?
Yeah, so to the extent that data transaction taps into existing repositories of data or biospecimens that were collected for research, the parties will or may need to contend also with the federal policy for the protection of human subjects, otherwise known as the Common Rule, and certainly the bounds of the consent that was obtained from individuals contributing to the repository. So the Common Rule applies directly to research that's federally funded, though institutions can elect to extend its requirements, including IRB and consent requirements, to all research that they conduct, regardless of the source of funding. And with respect to the Common Rule, again, de-identification can be a strategy, and that is because the Common Rule only views human subjects research as relating to activity that involves using, studying, analyzing, or generating identifiable private information or identifiable biospecimens. And the identifiability standards under the Common Rule largely align with HIPAA. So again, de-identification can be a strategy for leveraging and making available existing repositories. But it's important to note that there are certain privacy regimes that hamper the ability to rely on de-identification, and particularly where genomic data are involved. And this is, channeling the view that genomic data may be inherently identifiable. So, for example, the NIH, following the 21st Century Cures Act, updated its policy on certificates of confidentiality, which now automatically attach to research, certain research funded in whole or in part by the NIH. And this policy includes, it requires protection of identifiable sensitive information, which is defined to include individual-level human genomic data from biospecimens or the use of that data, and this is key, regardless of whether the data is recorded in such a manner that human subjects can be identified or the identity can readily be ascertained as defined under the common rule. So, in other words, NIH creates a much higher standard for genomic data that are generated with NIH dollars through a grant or otherwise, in whole or in part. That's going to be subject to a certificate of confidentiality, which limits subsequent uses and disclosures to really narrow lanes, and regardless of whether all other identifiers have been stripped. Really, again, channeling the view that genomic data is somehow inherently identifiable. Similarly, folks would be familiar that the GDPR sets a higher bar for anonymization of personal data. That's really a much higher bar than de-identification under HIPAA. And there are various state laws that place additional protections on genomic data, for example, beyond the requirements of HIPAA or the common rule, and may impact the ability to leverage certain data sets in a particular transaction. So all to say, it's important to know diligence and recognize the jurisdiction of origin for any data sets that are going to be brought to bear in a particular transaction. So with that roundup, we've talked about privacy considerations, but what non-privacy related laws and regulations should the parties consider in structuring and consummating a data transaction?
Yes, great question, Rebecca, because aside from privacy considerations specific to data transactions, any parties engaging in the kinds of transactions we're talking about today also need to navigate other federal and state laws that just are typically involved in deal structures, in particular deal structures between healthcare providers, many of whom receive reimbursement from the federal government for services rendered, and third parties. So just a few examples of some considerations. When a data transaction involves parties that may refer healthcare services or goods payable by the federal government to one another, which is often going to be the case in these kinds of transactions, the transaction must be structured to comply with the federal anti-kickback statute as well as other state statutes. We call them sometimes mini kickback statutes or all payer statutes that address referrals between and among entities. And what I'll mention just in terms of the anti-kickback statute is the terms of data transactions and the transactions themselves may not readily map to a traditional safe harbor under the federal anti-kickback statute, but the parties should look to the kinds of safeguards that we would put into place in deals involving healthcare entities that mitigate risk under the anti-kickback statute. So many of our listeners also will understand that where you don't necessarily fit into a kickback safe harbor, you aren't per se violating the law because the anti-kickback statute is a facts and circumstances analysis. So you look at all of the facts around a particular arrangement or transaction to determine whether it could be subject to scrutiny under the anti-kickback statute. So here, of course, valuation is critically important because you want to structure your entity in a way where any remuneration passing between the parties is fair market value. And that's really the most important aspect, and that any services rendered are necessary services to meet the purposes of the agreement, and that you're not providing more than what is needed, again, to satisfy the purposes of the agreement. Valuation is also important when tax-exempt entities are involved, again, which will often be the case in these kinds of transactions, just to avoid any issues related to private inurement or private benefit. And then just one other item that I'll mention, speaking of tax-exempt entities, is when the entities that are tax-exempt, or even one entity that is tax-exempt, is engaged in these kinds of transactions. And if the transaction is not related to research or doesn't involve direct patient care, then there's a risk it could generate revenue that might be subject to unrelated business income tax, or UBIT. And so in that instance, documenting the mission-centric purposes of the transaction and the ways that the transaction really furthers the party's tax-exempt mission and purpose are important steps to take to mitigate risk. So we've talked a bit about the considerations involved in these types of data transactions. Rebecca, can you walk us through then what some of the key contractual terms would be when you're negotiating a data transaction deal?
Setting aside just the typical provisions you'd want to address in any transaction definitive agreements, focus most specifically on those terms that are of key importance when data is the subject matter of the transaction. So obviously you want to memorialize representations and warranties that align with the regulatory predicates for the transaction. Certainly defining the rules of the road for data access, use, and disclosure and any associated restrictions are important for the contract, as well as, having some level of specificity around the supporting data architecture that's going to meaningfully implement those access, use, and disclosure restrictions, including auditing and monitoring rights to ensure contractual compliance. Certainly the parties are going to want to address intellectual property rights and the rights to the data, as well as the rights to any resulting discoveries. Obviously that's the key value to be derived from the transaction. So that'll clearly take center stage in the negotiations. With respect to data, right, that's the value that's being created through the initiative. The parties should think through data backups, data security, disaster recovery plans. Some of these, particular genomic data are involved. It's just incredible amounts of data that are associated with large storage and compute costs. And the parties need to allocate those costs and think through how they're going to handle backup, as well as data transfer, either during the term of the agreement or upon the end of the arrangement. And return or destruction obligations should align, of course, with the data ownership that's assigned in the transaction definitive agreements. And one last thing I'll mention, again, just with a focus on terms that emphasized or enhanced importance in a data transaction, is being really clear about the penalties for misuse. So the backstop or the teeth to those access, use, and disclosure restrictions, whether that's going to take the form of a liquidated damages amount for misuse, and certainly indemnification for breach or any third-party claims that might result from a party's use of data arising out of the transaction. So those are just a few of the contractual considerations I guess I'd put on the table.
Great. And so as I'm listening to you and I'm thinking about the topics we've covered, we've talked about certainly the privacy considerations as well as other regulatory considerations. We've talked about how to structure your deal to protect those interests as well as others. How are institutions getting their arms around responsibly pursuing these kinds of transactions, Rebecca, so as to comply with the regulatory structure that we've outlined, as well as to mitigate risk and to assure an ethical approach?
Yeah, thank you. A very timely question. So I think a number, maybe a majority, all institutional providers and other stakeholders on the provider side in this space are at some stage of evolution in their data governance policies and procedures. So either, establishing formalized data governance committees and policies for the organization, or enhancing existing structures to more directly contemplate and adjudicate these opportunities in a consistent and intentional way with the right stakeholders and constituencies from the institution involved, both from a security and privacy perspective, but also from a legal and operations, a clinical perspective, so that there's a balanced consideration of both the value of the transaction as well as the risks associated. And so in addition to, ensuring that the data transaction can permissibly be achieved, in compliance with relevant laws and regulations, the purview of these types of data governance committees may also include, confirming it should proceed from both an ethical and a reputational perspective. So is the value to be gained from the transaction aligned with the institution's mission? Is it patient first, patient centric at the end of the day? Is it going to, if it's, a publicly announced initiative, gonna have reputational impacts, positive or negative, on the institution's, on folks' view of the institution as an appropriate and responsible steward of the data entrusted to it. And then these committees may also have a role in, defining those contractual terms that we just reviewed and how data transactions are going to be implemented to mitigate risk and ensure the value that is intended is actually materialized and gained. So with all of that, I guess, Gina, I'd ask you, sort of your key takeaways or how you'd bring us home on this topic.
Thank you, Rebecca. I frankly think the subject that you just discussed in terms of data governance and the ethical and reputational issues associated with data use are truly fascinating. And I am struck with the takeaway that healthcare is such a dynamic, changing environment in many ways. And the proliferation of these types of data transactions is really just one illustration of that. In particular, as we see increased technology capabilities merge and some might say collide with the provision of healthcare and the ability to generate enormous volumes of data that have great potential to further develop the tools and the technology and the knowledge that will increase healthcare capabilities and opportunities for people to stay healthy. I think by and large, the proliferation of these types of transactions is a good thing and will help our clients on the provider side to have access to enhanced technology and increased capabilities to treat their patients, while allowing those involved in the development of these tools and products and devices used in the treatment of patients to help further develop and enhance those products. And I think there is truly a recognition of that among healthcare providers, as I mentioned earlier, and a shifting in terms of their willingness to enter into these kinds of data transactions, which is, causing us to see more and different kinds of transactions occurring. But it is important, whichever side you are on in that transaction, to be mindful of the protection of data and the other regulatory considerations that are relevant, a few of which we've discussed today, and to have good contracts in place and to seek competent, experienced legal advice that will help you navigate those negotiations, as well as a system within your organization of governance and compliance to assure, that you're getting an end product that checks all of those boxes. So with that, I will just thank our listeners for joining us today. We truly are grateful to our Triage listeners. Thank you for listening.
Thank you.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.